Hi there, it's Wendy Hernandez with Command the Courtroom. And in this week's video, I want to talk with you about balancing the very fine line between advocating your case and annoying the crap out of your judge. And I have had some personal experience with this in the last couple of months, unfortunately, because I've found myself involved in some really high conflict cases that have ended up at trial. And in these cases, not only have the two parties been at each other's throats, but the attorneys, meaning me and the other attorneys, have been at each other's throats. And, just the conflict of the situation have brought these cases to a whole nother stress level that I'm used to. The conflict has brought these cases to a whole nother level of intensity in the courtroom than I'm used to. And so in arguing for my client's position in these cases, there's one judge in particular who's really gotten fed up with not only me, but with the other attorney in the situation. So, for example, judges set disclosure deadlines in cases. I've talked about this in other videos, how you have to abide by the deadlines of the court. In one of these cases, past the disclosure deadline, the other side disclosed an expert witness to evaluate some of the parties' financial accounts. And of course, my client freaked out and I freaked out because we got this information 2 weeks before trial. A 57-page report filled with tables and charts and graphs and numbers. And there was just no way that me and my client were going to be able to figure this out prior to trial, especially without an expert of our own. So I did what I thought most attorneys would do, and I filed a motion. It's called a motion in limine. And I asked the judge to strike that report and to stop the expert from testifying at trial. Well, of course, the other side promptly responded with their own motion, their response to my motion. And in their motion, they accused my client of not timely disclosing some of her financial information, which led to the late disclosure of the report. And then, of course, according to the rules, I'm allowed to file a reply. So if I'm allowed, then I felt like I needed to, and I filed a reply. The judge was not happy, to say the least, and he issued a minute entry and basically said, I'm not going to decide this issue before trial, which is 2 weeks away, and I'm going on vacation between now and the time set for trial, so I strongly suggest that the parties get together and figure this out. And I could almost just feel the frustration coming from the judge's minute entry. I could feel his anger, and I thought, oh gosh, we better try and work this out, because if we take this to the judge, it's not going to be good for anybody. And that's what my client and I attempted to do. Luckily for her, she had the resources to get her own expert who was able to do an analysis of the other expert's report prior to trial. And by the time we showed up for trial, we had resolved the issue, and the judge said, it's a good thing you worked it out because you were able to avoid my wrath. So, there's certain things that need to be done to protect your interest in a case, but sometimes you just need not push it. In this case, I thought it was a situation where I needed to file that motion to protect my client. As another example, just last week I had a trial, and there was a particular document that my client really wanted to be admitted in evidence. And I tried to get it in a number of different ways. And basically the judge told me, I'm not admitting this exhibit. I don't feel comfortable admitting this exhibit. And I got the look like, don't push it. So I just dropped it. And you really have to be mindful about when you're getting to that line of pushing it and when you're ready to cross over that line. Because I've been in cases where the other party or the other attorney has not been mindful of that or has not been aware of that, and they've crossed the line, and what's happened is they have experienced the wrath of the court in the form of a ruling that did not benefit their client. So it's a fine line between advocating and annoying. Remember that. If you like this video, remember to give us a thumbs up, follow us on Facebook, subscribe to me on YouTube, and until next week, remember to keep on trucking and command the courtroom. And you can say hi to my daughter right there. Say hi.